Welcome to the Sui Generis Show, your unique perspective on everything you need to know about your civil rights and the criminal injustice system. With Erica Merrill, I'm attorney Brian Jones, criminal defense and civil rights warrior. Today in segment 1, we'll be discussing law enforcement's use of your location services on your phone to identify people that are accused of crimes, and one particular instance that is troubling. An attorney has been accused in a murder for hire plot of himself, and the FBI has decided to accept review of the Columbus, Ohio Police Department. In segment 2, as promised, we'll be discussing the use of SCRAM units and how privately held corporations are strapping little computers to your ankle to monitor your use of alcohol. Make sure you don't miss an episode by subscribing on Apple iTunes, Spotify, and YouTube. And look to the law office of brianjones.com and all of our social media outlets for everything you need to know about your civil rights and the criminal injustice system. Erica, did you see in the news this week that a robbery has posed a legal test for the courts in reviewing law enforcement's use of location services data?
I mean, this is really interesting, and I'm not sure how often this occurs, but it is the first time that I've heard of this. What is Google location data for those of us that don't know?
Location data is recorded when the user agrees to share location history with Google or Apple or any particular service provider. Most frequently, we're referring to Google, though. It's literally a switch in your device's settings that you can turn on and off at your whim. Now, when you turn on location history, it allows the phone to send GPS tracking signals to any app that you have authorized to receive that information. And that includes things like real-time traffic predictions and status updates, transit information, and restaurant recommendations for the location that you're in. Now, the location data is more precise than what law enforcement has historically used, which is cell tower access data. Now, cell tower access data says that a particular phone has connected to a particular cell phone tower. And that gives law enforcement a general idea of where that phone was when it was connecting to that tower. But GPS signals can narrow and shrink that circle down very, very small. And it uses both GPS and Wi-Fi networks that are near the device to find the precise location of that device at the time requested.
I mean, it sounds a little like when you tell us, don't send your DNA into the ancestry companies because then they have your DNA on file. I mean, it sounds like this might be something where you want to really be careful about allowing some of these apps to track you, because I know lots of apps that I have asked me if I'd like to turn on tracking and my location.
You're absolutely right, Erica. The use of this data to give you services is incredibly convenient, and it's very beneficial to you and I. But what we have to recognize is what we're giving up in exchange for that convenience. And in this situation, we're giving up our precise location and the time that we're in that location. Now, you may trust private corporations with that information. And when you made that choice to give up that data, you very well may have thought, well, what's Google going to do with this information anyways? Without having any thought about the fact that Google's going to give this information directly to the government.
I mean, and that's what we have to think about nowadays with lots of things. And I'm so happy that you bring these situations to light, because, you know, it's not something that I would think about, not being someone that is in a criminal situation. So, I mean, you just don't want to give away your location to everyone. So maybe tell us, how do geofencing warrants implicate the Fourth Amendment?
We have to go back to 2018 to understand the answer to this question. Back in 2018, the United States Supreme Court decided the case of Carpenter versus the United States. And what they said in that case was that historical cell tower data location information, you need a warrant for the police to get that information. Now, fast forward to 2021, massive leaps and bounds in technology have occurred in the last 3 years, as they continually will do. And police have now started asking for what they call a geofence warrant. That is a warrant in order to seize all of the GPS data for a location rather than a particular user. So just think about a map. And in this particular case that we're going to talk about today, think about a gas station and draw a circle around that gas station. And anybody who enters into that circle, or rather any device that enters into that circle, that information is now turned over to the police, and they can start investigating you for any crime that they want. Now, this is unique because warrants are required by the Fourth Amendment to the United States Constitution to be supported by probable cause of a particular crime being committed by a particular person. Never in the history of the United States has a warrant issued to cast a net over every person who is in a particular location at a particular time. There is no reasonable suspicion of these people. There is merely a hunch that somebody who was there at some point has committed a crime. And this is being used to collect the data on everybody who is in that location at that time, guilty and innocent people alike.
I mean, this sounds like one of the scariest things we've talked about, because an average citizen can be accused of a crime, and they do it all the time. And even if you are proven innocent later on, your life is wrecked quite often while you're going through a trial, because people make decisions about you, and it can be really scary. It can affect your home life and your job and everything else. So maybe can you discuss a little more about how this case affects the average person's privacy rights?
Okay, I think you've hit on something that's really critical here, and that is this: the mere allegation of having been involved in criminal conduct is enough to absolutely destroy a person's life. I have had clients lose their jobs, lose their children, lose their homes based on the mere allegation of criminal conduct. And that is what this type of illegal search and seizure should be designed to prevent. The courts must step in and say, this is unacceptable. You cannot gather everybody up that was in a particular location at a particular time and start accusing them of criminal conduct. The government isn't supposed to be able to round up everybody regardless of a legitimate supporting threshold of evidence. You can't just gather everybody up and gather everybody up and sort through them like a herd of cattle. They are basing their suspicion on unequal and biased policing techniques. Because you are at a location where a crime was committed at some point, you are therefore a suspect in that crime. In this particular case, an individual was accused and arrested and is facing charges for a bank robbery based on geofence warrant location data. Think about that, Erica. Just because you went to the bank within an hour, 2 hours, who knows what the window was of that bank being robbed, you are now under suspicion for that bank robbery. You are now subject to have the police come knocking on your door. You are now suspect and at the whim of the police to come and pull you out of your place of business to interrogate you. You are at the suspicion of the police, and they could come to your children's school and arrest you in front of all of your children's friends and all of the other parents because you were banking on the wrong day. There's no proof, even in this case, that the phone in question was in the accused person's possession at the time that the phone was in that banking location. There is zero evidence to identify the individual and accuse them. And that should be terrifying to everyone out there. Now, in this particular case, Google isn't taking any position, and they haven't filed any briefs looking to protect their consumers' data. And I think that is a secondary problem. Apple has time and time again stepped in and fought for the privacy rights of their users. And in this particular case, Google says, that's your problem, not mine. Now, the average citizen has to weigh the convenience of having those local recommendations, knowing those real-time traffic and transit updates, versus your right to privacy, free movement, free association, and freedom from having the police kick in your door because you went banking an hour before somebody decided to rob the bank. I, for one, recommend that everybody turn off their location services and only turn them on when it becomes necessary to use them.
Well, I really appreciate your giving us more information on that. It's shedding a light on something that could cause a lot of problems later on and a lot of headaches. So thank you so much.
Thank you, Erica. And I just want to make sure that everybody out there stays informed and makes informed choices. The police rely on your ignorance, and I want to pull that curtain back and let light in where law enforcement wants to maintain darkness. Let's move on to our second story today. And Erica, did you see in the news this week that Alex Murdaugh's attorney has come out and said his client will be turning himself in shortly?
This case is so crazy on so many levels. So I can't wait to talk about this. He's talking about turning himself in. That's really interesting. What are the circumstances that led to this lawyer being accused of a crime?
The allegations presently pending against attorney Murdaugh involve a plot by him to have himself murdered via gunshot wound to the head so that his son could collect an insurance policy. Mr. Murdaugh has been surrounded by intrigue and tragedy long before this set of allegations. His housekeeper died, and he was sued for her wrongful death. His wife and son were shot to death in 2018, and those murders remain unsolved. And he's been under investigation by his law firm for misappropriating funds. Mr. Murdaugh's attorney has come out and addressed the media repeatedly about his struggles with addiction and has issued statements on Mr. Murdaugh's behalf as he is trying to right his addiction ship.
It's really interesting, and I'm sure you can tell us about the strategy behind this, but why would Murdaugh's attorney allow his client's intent to turn himself in be known?
So Murdaugh's attorney has been really active in the media, countering the salacious press coverage that has been directed at him. And he's been out front making statements that humanize his client, and in particular talking about his client's emotional suffering and addiction issues. Announcing this intent to turn himself in provides Murdaugh with cover should the police choose to come pounding on his door before the time he's agreed to turn himself in. It sets the police up to look like the bad guys if they rush the process and try to arrest him before the agreed date that he's going to turn himself in. Now, it's a tough call to decide whether to make public statements about this, but I think in this instance, with the volume of media attention that this case has received, I think it's necessary and it's wise because it really provides significant benefits to Murdaugh over the course of his case.
So that's really interesting. I mean, you're talking about the police looking like bad guys if they pounce on him after he's already said, hey, I'm turning myself in. Are there any other benefits to turning yourself in?
There are, Erica, and the significant benefit here, the most pressing benefit, and applies as it relates to the issue of bond and pretrial release. Murdaugh has to know that he is going to jail when he turns himself in. And turning yourself in, knowing that you're going to be incarcerated, even if it's just for a few hours, establishes credibility with the court. And when the person later says, I will absolutely show up for all of my court dates, and I am subjecting myself to the jurisdiction of the court, and I intend to fight these charges, that narrative becomes more believable when you turn yourself in at the outset of the case. And it really takes the government's narrative and turns it on its head, because the government wants to create a picture of somebody that's avoiding responsibility, somebody that's not trustworthy, somebody that is a criminal. And by reaching out and saying, we are going to turn ourselves in, we understand that there are going to be some limitations on our freedom. We want to establish our innocence in front of the court, and we want to build trust with the court. Doing that by turning yourself in early in the process shows cooperation and respect for the system, and it really reclaims some credibility in the eyes of the public. Now, depending on the circumstances of the warrant, it also reduces the chances of a violent and potentially deadly confrontation between a citizen and police. And therefore, it protects both the accused person and the accused's family from the potential of being shot to death by a police officer.
I mean, thank God for that. I mean, and there's always one part in every interview we do where it's like, man, you really need an attorney. Because when you're talking about how to really like discuss his addiction and help his family through this and really show him as a human being rather than this person that's involved in this crazy plot to get insurance money. I mean, that's super important because it just shows to his state of mind. And, you know, why would somebody do something like that unless they were under severe stress and, you know, need some help from a therapist or whatever the court deemed necessary.
I think you're absolutely right. And this is why at the first sniff of allegations, you should be reaching out, finding an attorney, because, you know, time and time again, these sorts of situations can be completely cut off at the knees by the involvement of an attorney early in the process. The problem starts to compound itself when, you know, citizens who have lived their lives in the darkness never see the light, and they go and they make these little mistakes, one after another, that creates a bigger and bigger problem for the attorney that is ultimately coming into the case is going to have to solve. So you're absolutely right, Erica. You've got to, as soon as you become aware that you might be charged with a crime, that you're being investigated for a crime, you need to find and hire a criminal defense lawyer, a lawyer who focuses their practice on criminal defense, more than 90% of their practice on criminal defense. Absolutely.
Hey,
100%.
I'm sorry. And hey, you may need to call one if you happen to be in an area where there's a bank robbery. I mean, it's getting crazy, but definitely give an attorney a call, especially Brian Jones, if you're in that area.
Thank you, Erica. So last but not least, did you see in the news this week, Erica, that the United States Department of Justice has accepted the Columbus mayor's call for review of the Columbus Police Department?
That sounds serious. Why did the mayor ask for the Department of Justice to review the police department?
2020 was a bloody year in Columbus, Ohio. The mayor's request came soon after the police shooting of Ma'Khia Bryant. She was the foster child who was calling for help and trying to defend herself from a physical assault when she was shot by a Columbus police officer mere seconds after he arrived on the scene as she was requesting police assistance. Now, that shooting came on the heels of another police shooting, I guess a rash of police shootings in 2020, including the shooting of Andre Hill. And the people who shot Andre Hill are now on trial for his murder. All of this violence perpetrated by the Columbus Police Department on minority members of our community, almost exclusively Black members of our community, led the mayor to make this request to the Department of Justice's Civil Rights Division. And this is the unit that has the power to enforce citizens' rights under the United States Code, Section 1983. It's a proactive step, Erica, and it's in response to what has been outspoken public outrage, but it's also a practical step, and it gets ahead of what is likely an inevitable investigation, considering how bloody Columbus has been in the last 18 months. It creates a cooperative situation rather than a confrontational situation for this upcoming investigation. Now, City Attorney Zach Klein has acknowledged that he is participating in this process, and he's volunteered to share information throughout the review. And in this manner, the city avoids the expenses of litigation that could happen when the Department of Justice forces a review on the city. So rather than going through litigation, through discovery, depositions, investigations, subpoenas, and ultimately maybe even a trial, the city has circumvented all of that and gone straight to, yep, let's open our books, let's review everything, and let's reach an agreement as to how this should be done. I applaud the city of Columbus for taking responsibility and recognizing that the behaviors of the past cannot continue in the future. This is a great example of the consequences of an election and a reminder as to how important it is to vote for the candidates that support civil rights. The confrontation of institutional racism must occur on a daily basis, and at the ballot box is one of the most important locations to fight that. It will lead to police and criminal justice reform. And as you can see here in Columbus, it is already happening. So, this review was instituted by the mayor because it's what the people wanted, and it's the most efficient use of government resources in the situation that's being presented.
And that's amazing. I applaud them as well, because we've all talked about how afraid people can be to make changes, especially where law enforcement is concerned, and they saw a problem and they are looking to fix it. So that's fantastic. So is the Department of Justice's acceptance of the review significant?
Well, I think it is on a variety of levels. The Department of Justice could reject the request and just sue the city. So the Department of Justice has also come to the conclusion that the city wants to participate with transparency. And so the Department of Justice is also willing to go through this process without the need for litigation. And it really signals that this cooperative process will result in a thorough and transparent review and likely some changes in policing in Central Ohio. The other significant factor in this review is, or their acceptance of this request for review rather, is the Community-Oriented Policing Services Office, which is a federal agency, will provide resources and assistance to the city of Columbus at no cost to our local citizens. So again, this is fiscally responsible. This was the cheaper option, and it is going to create better results. The city will have to pay to implement any recommendations, but the whole litigation process, the whole investigative process is now at the financial expense of the federal government. The Community-Oriented Policing Services Office will also provide an in-depth analysis and review of existing policies and procedures. Any peer-to-peer exchanges, they're going to facilitate discussions, they're going to facilitate training. It's really a fantastic opportunity for Columbus to move into the 21st century and start to bury its history of violence towards marginalized communities.
Well, Brian, I can think of a lot of other cities that could do with a review and some change. So hopefully they are the first in line of many. And I'm sure other cities have done it as well. But it's a
irony. Oh, go ahead, Erica. Sorry.
Oh, it's just a really good, it's a really good process to see going, and I'm hoping that we see more and more of it in the future.
Absolutely. And you say there are, you can think of a lot of other cities that you think could benefit from this. And what comes to mind immediately is, well, cities across the American Southeast, right? But the irony is that many of those cities, when we think about places like Atlanta, Memphis, cities in Virginia and even Florida, have been forced into this process. And so they've already gone through that change. And they're some of the most progressive police agencies in America. Now, they still have their problems. But the irony is that you would think places like New York and Chicago and Boston would be the more progressive police forces, Columbus, Cleveland. But the reality is that these cities in the North have done a very good job of covering up their institutional racism. It's just the South is just really transparent about how racist they are.
I agree with you. A lot of times people just assume that the South is full of racism, and I'm glad that they have some transparency. So can you give us a little more information about what exactly is reviewed as part of the process?
Police Chief Elaine Bryant has identified several areas that she believes the Department of Justice should focus their attention on. Primarily, use of force. Obviously, with as bloody as 2020 was, Columbus police need to review and reconsider how they deploy force against the citizenry. Included in that, proper training in the use of force, de-escalation training in particular, recruitment for diversity, eliminating bias-based policing practices, identifying early warning systems to weed out the bad apples, so to speak, the police officers who are most likely to violate citizens' rights and engage in violent conduct towards the people. The use of technology to move Columbus Police Department forward, and of course, staffing and community relations in general. You may recall, Erica, that the Columbus Police Department was previously accused of internal bias and racism in its promotion and employment policies, and that there is presently pending a federal civil lawsuit filed by multiple police officers against the Columbus Police Department. So this investigation will also look at the Columbus Police Department's hiring and promoting practices, as well as their recruitment policies, and it could accomplish many of the reforms sought by the plaintiffs in that suit. One of the major problems with policing in America today is that the vast majority of law enforcement officers are white men, but they are policing a population that is increasingly not mirroring their makeup. So the police department is 70, 80% white males, whereas the community is 51% female to start out with. But then it's more like 60% white, Maybe it's 50% white, 55% white, 65% white in some communities. And that reflection of the diversity of the community in the color and diversity of the police department is critically important to empathize between law enforcement and the citizens. Note that the process could change if the police department is not cooperative and they're not forthcoming in the review. And the investigation could turn into litigation or a consent decree, which is still a tool that's available to the Department of Justice. But I think what you're going to see is, Chief Bryant is going to be transparent here. And I think you're going to see some real change coming to Columbus, Ohio.
I'm so excited to hear about that. Thank you so much for giving us the details.
My pleasure, Erica. Again, just trying to pull back the curtain where the police don't want the light to shine. And speaking of an area that law enforcement doesn't want light to shine, SCRAM devices, secure continuous remote alcohol monitoring devices, are worn 24 hours a day, 7 days a week, 365 days a year by people who have been merely accused of committing a crime. These devices are often part of pretrial supervision and can continue throughout the process of a criminal trial and into post-conviction supervision. How is this a legal way to monitor someone who has not been even convicted of a crime? Today, Erica, let's discuss SCRAM units, what they mean for our rights, and what are they?
That is interesting. Wow, SCRAM devices don't sound legal. I don't know why. Tell us exactly what they are, and maybe we'll have some light shed on that.
Well, as we said in the lead up, Erica, a SCRAM is a secure, continuous, remote alcohol monitoring device. It's a bracelet that's worn around the ankle, and it has sensors that are pressed flush up against the skin. And the unit monitors for the presence of alcohol every 30 minutes, 24 hours a day, 7 days a week. The bracelet is constantly testing the person's sweat for alcohol. It is most frequently used as a condition of pretrial release. The SCRAM device is imposed at the cost of the accused person. However, there are some situations where the fees can be waived through an appropriate request to the court. But the reality is, Erica, is that 95% of alcohol is metabolized by the liver. 4% is expelled through the lungs and the kidneys. And the remaining 1% is eliminated through the skin via sweat. So if you've ever noticed an aroma coming off of a person who drank hours and hours before, this is called transdermal secretion, or through the skin expelling alcohol from the body. The bracelet should distinguish between alcohol secreted from the body and the presence of alcohol through things like lotions, soaps, perfumes, or alcohol that's just hanging in the air.
That sounds like it's going to give some inaccurate readings. It sounds like more reasons for people to be falsely accused. How is the continuous search of the body legal under the Fourth Amendment anyway?
The device is most frequently used as a condition of bond, and it's therefore a compromise of a person's Fourth Amendment rights. You give up your right to be free from searches, and in exchange, the government doesn't keep you in jail while your case is going through the court system. Under a Fourth Amendment analysis, the court has sufficient probable cause to believe an offense has occurred by the fact that a complaint has been filed by a sworn officer or an indictment has issued. That means there's a legal foundation for the court's decision to impose supervision while the case is pending. And the accused has a choice. They can choose not to wear the SCRAM device. And if they choose not to, they can stay in jail, and then the court is certain that they're not using alcohol. And continuous means continuous. That means the device is on you when you're in the shower, and you have to charge it overnight while you're sleeping to make sure that the battery is still staying connected. And I think you make a really good point, Erica, that this technology has its flaws. For one, I mean, everybody has experienced their cell phone battery having issues. And that's the number one problem that I have seen clients run into, is the batteries in these devices are just terrible. And so they go, they wake up in the morning, they go to work all day, and it's dead before they get home from work to charge it. And the second is, the second most frequent problem we have with them that my clients have experienced is the device literally will rub your skin off. Think about having two pieces of metal up against your skin 24 hours a day. That skin moves and stretches, and it just rubs and rubs and rubs and rubs. And we have seen significant irritation. Last but certainly not least, everybody has had connectivity issues via Bluetooth or Wi-Fi. And these SCRAM units are no different. This is a wireless connection that is uploading data. And we have seen time and time again, these units go dead, and our clients get accused of tampering with the device, or in some way interfering with the device's functioning.
I can absolutely see that. I mean, we have so many devices now, and it might even be that you have so many things connected to your internet that it's just very slow and it may not work properly. Heck, before this interview, you were shutting down apps to make sure that you had the optimal connectivity for this interview. So those are all really great points. So what happens if the technology does malfunction?
So it really depends on what stage of the process the person is being subjected to it. In a pretrial supervision situation, there is the right to counsel obviously present. So the court can revoke your bond and have the police come and pick you up and hold you in jail until the court can figure out what happened. Was there an actual violation, a use of alcohol? Was the device tampered with, or was this a malfunction? Post-conviction, this now results in a violation of your probation terms. That can result in the imposition of a jail or a prison term. So again, the right to counsel is important. And as we've discussed, knowledge of this technology is critically important for a criminal defense lawyer, because you've got to be able to defend these allegations, whether that be a technology failure, a systems failure, or a user failure. And the thing is, these devices continue to advance, and with their advancement comes more and more problems.
Well, and absolutely, technology is constantly changing, and that's why it's great that you update us on this. So I'm happy to hear about this. I'm glad that, when you have an attorney, they can point all of these issues out. I mean, this sounds a lot like when we're talking about the breathalyzer or many of the other issues that you have with DUI arrests. And, it's just another thing that you have to really pay attention to the technology and make sure that it's working properly and that it's actually doable for real life.
You're absolutely correct, Erica. It's critically important to have that knowledge and to challenge it when it's appropriate. I appreciate you engaging in our discussion today, Erica. Thank you for joining me, and to everybody out there listening, thank you for joining us. To stay informed about the government's use and abuse of your cell phone's data, police accountability, SCRAM units, and all of your constitutional and civil rights, look to the law office of brianjones.com, or find us on our social media channels, facebook.com/Central Ohio Criminal Defense, and at TLOBJ on Twitter, Instagram, and TikTok. We'll be back next week with a sui generis perspective on the next big thing in civil rights and criminal injustice system news, as well as a discussion of driving privileges when a license has been suspended due to an administrative or DUI suspension. Erica, my grandfather always told me, hey kid, don't do anything I wouldn't do. And to that, when I part ways with my friends today, I add, if you do and you get caught, call me. I'll defend your rights as I'd want mine defended.